Welcome back to the Uncommon Area, Sandra. Glad to have you back for another episode.
Thanks so much, Matthew. I'm so happy to be here.
Yeah, well, this is, I think, a topic that is not commonly talked about, and so I'm glad that we're going to be able to unpack this today. And we're going to be talking essentially about when public access meets private communities, and how do we navigate those types of things. So maybe to introduce the subject, you could talk a little bit about what are those scenarios that we're trying to get at.
The scenarios where public meets private for homeowners associations typically occur when we have trail points, or we're talking about if all persons have access to public beaches even over private land.
So there's two primary, this probably goes to a lot of scenarios, but two primary scenarios would be like trails, probably primarily like horse trails, hiking
and walking,
trails.
hiking.
Yeah. And then also scenarios where there might be private beaches that intersect with public access.
Correct.
So what are some of the things that an association should be thinking about on this subject, or where do the problems come up?
So for me, the issue always has to do with liability. Association owns the trails. People are hiking or using them for equestrian use, and somebody falls off a horse or they trip on the trail. And the association is the owner. They are the likely defendant in that scenario. Fortunately, there's a law that allows the association to provide this access through easement rights and avoid the liability as a entity that is providing this access, specifically saying you can come here by law, but we're not responsible unless we were grossly negligent. And then there's a question of, did we know there's 4 feet of gopher holes, and how long did we know about it? Did we do anything about it?
Okay. So I think we'll probably come back to that a little bit, but essentially what you're saying, if I was just to summarize this back, associations can have their own private land, which could be a trail or a beach or whatever it might be, and there could be easements that allow the public to have access, and in exchange for the association granting access to the public, the association is let off the hook, for lack of a better way to say it, on certain liability as long as they don't do something that is grossly negligent.
Exactly.
Well, let's take a step back for a minute and just talk about what are the different types of ownership rights or property rights that an association can have over property.
So we have what we know for homeowners associations is common area. Large associations might have the common area owned by the association with an entitlement of use by the homeowners. More traditionally, you have common area and everybody has an undivided interest in the whole to use the common elements. There's exclusive use common areas, so that's more than one but less than all. And we think of that usually with associations that are condominiums or townhouse projects where somebody has a balcony or a deck. So maybe 2 people can share that deck in a townhouse situation. So it's less than all but more than one.
Okay. So let's just unpack those topics, and then we'll be coming back to the public access portion in a minute, but I want to make sure that we're understanding the association's property rights. Let's clarify one thing that I think is often maybe misunderstood. Does the association actually own the common area?
Traditionally, no, but the answer is in the governing documents. It will tell you in the CC&Rs, and it will be validated either by a tract and plat map or a condominium plan in the legend who is the owner of those common area components.
So if the association doesn't own the common area, then who does?
The homeowners own it in an undivided interest. So each of them own a share of that property, but they don't own a 1% share. They have access to all of it, subject to guidelines, rules and regulations, policies and procedures, those things that go to the governance of the association.
So that's the more typical structure.
It is.
So usually, and the documents can state otherwise, but usually the association as a corporation doesn't actually own the property. Now, for 99.9% of the situations, it really doesn't make a difference practically in either of those scenarios.
It wouldn't make a difference.
Yeah.
Exactly. It makes a difference when people think they have a sense of entitlement that possibly they don't. And we want to make sure that they understand this isn't us trying to keep you from something that
right.
you own or that the association owns. So it's a question of communication on that issue.
Sure. And then now we're going to be connecting that to public access. What are the different ways to think about public access of an association's property or the property in an association?
So a public access happens usually by easement. And so the first thing that I advise our clients that have trails for either equestrian or for walking is let's find out what's recorded against this association and who has access to those easement areas. And if there is a recorded easement. If the public is coming in, there's going to be a recorded easement, unless there is no recorded easement. And then there's something called a prescriptive easement, where somebody has for a period of time, no less than 5 years, and we want to check each state for the number of years that this will apply to. But for a number of years, they have used that property openly and notoriously, not hiding that they're using it. And it creates a prescriptive easement as if the association gave the easement right to those people who are claiming the right to access.
Again, I'm just going to try to repeat this back for clarity. If there is a trail going through a community and the public is always using the trail, there's no easement, but it's just a kind of consistent basis. People walk through, use the trail. Everybody knows that that's what people do. At a certain point, that becomes essentially equivalent to as if there was an easement.
Absolutely.
And that would be called a prescriptive easement.
That's correct. And I do want to say one thing on that. Sometimes board members will not want to stir things up in the surrounding community. And so they allow that to happen, not understanding the consequence of doing that could result in losing that property right. Doesn't mean it transfers to somebody else, but that access that people are using on those trails is now their right. They have the right to access.
Maybe I'm getting a little bit ahead of this, but an easement, an actual easement, you were saying will oftentimes, if not always, have some type of release of liability to the association.
We try to put that in all easement agreements.
Right. If you have a prescriptive easement, you don't have that defined in that way. So how is the liability portion treated? And is it any different in a prescriptive easement situation versus an easement?
No, because we have something called the California Immunity Act, and it's a statutory act, and we have that in 40 of the states. So that, and this happens a lot in public parks, federal parks, and so also state parks and areas. So it extends this protection to even homeowners associations, that if you are allowing people to use recreationally your property, either by easement or prescriptive easement. There's something also called an incidental easement, which is not necessary for us to define today. But if you're doing that, you are treated as if you were somebody who came upon a car accident, helped somebody, ultimately they were paralyzed by your actions, and they want to sue you for liability. In that scenario, we do also have the Good Samaritan law. It's the exact same thing for a homeowners association that's going to give them the immunity for the use of their property.
Okay. And then there's something called an implied dedication. What is that about?
It's very similar to the prescriptive easement. Again, you took no action to stop the use, and therefore it's implied that you meant for it to happen and we're giving that property right, the access, not the ownership, to the person who's using it.
Is there a difference between that and the prescriptive easement?
It doesn't have the same criteria for the number of years that's relevant in a particular state. And how the open and notorious thresholds are met are different in an implied easement.
Okay. Is there any aspect in which Davis-Sterling would apply to this topic in general?
Davis-Sterling applies because we're talking about common area components, responsibility to maintain, repair, and replace those common area components, and we're assuming that the trails our common area, and that's how we got into the situation to begin with. So I think there is some liability if we are grossly negligent, which is why the maintenance and repair responsibilities of the association under Davis-Sterling and under the governing documents really should be met. So events don't occur where all of a sudden our version of the Good Samaritan law is impaired because we failed under the Davis-Sterling Act.
So let's say, going back to what you brought up earlier, there's some gopher holes in a trail where there is an easement or a prescriptive easement. The public is accessing a trail. Somebody comes along and sprains their ankle because of one of the gopher holes. The association is aware that that happened, and they do nothing about the gopher holes. At a later date, somebody else comes along, sprains their ankle again, and they say, hey, association, you should have known, you should have done something about that. That would be the kind of scenario that might lead to an association potentially having liability.
That's when the second incident, it's not that you get the first one for free. You didn't know about it.
Right.
Once you know about it, under Davis Sterling, you have to take some affirmative action. So I would say to all associations that have trails for access for whatever purpose, to make sure that you are budgeted for the maintenance and repair of those trail components, so that if there's an issue, you're able to remedy that situation as quickly as possible.
All right, so let's talk about going to the beach. How does
I love that.
Yeah? How does the California Coastal Act apply to scenarios where associations may have beach property?
I call that AKA the bane of my existence.
Oh, really?
And the reason that it is because their job is a little bit different than mine. I have a number of associations that are sitting right on the beach throughout my state. And the use that's required from the Coastal Commission is certainly different than the associations who traditionally, if they're beachside, are of high value and high net worth owners who believe they don't want to share their private space with the Coastal Commission's authority to allow access for everybody.
And so how does that get addressed or resolved?
So there's a lot of court cases on this. One is called Hollister Ranch, a very big case, 14,500 homes. In the Hollister Ranch case, the association was upset with the Coastal Commission because they were tying approvals to whether or not somebody was going to allow access to their private beach space. And so that's a huge case. There's another case where a multimillionaire who put up a gate at his beach access, and the Coastal Commission said, you can't do that because you would have had to come to us to obtain authority to obtain a permit to put that gate up. And you changed all the rules by closing off your access gate, even though to get through that access gate, there was some what's called high tide water. Let me take a second and tell you what that is. It's actually the right of access to public beaches. And high tide water is as simple as wet sand and the ocean. Anything that is not wet, which is in your owner's private space, is literally their private beach. What happens in these situations is people obtain the authority to lock down their private space on both sides of their property. And so getting down from a street, going through a possible slope area to get to the beach will be restricted because the owner has authority within their square footage of their property that they bought. But if there is another way for a person to want to come to the beach, that they can get in not through that owner's private property, they literally can set up in the wet area, meaning the wet sand area, and have their day at the beach, even though 2 inches away from them is that owner's private beach area. The Coastal Commission is very interested in those scenarios, more so when they are granting approval than when dealing with existing properties.
So just again, to reiterate, a homeowner who has dry sand on their property and that going across that dry sand is the only way to access the wet sand, a homeowner can prohibit that kind of access to the public.
Can, unless they were directed as part of their building permit by the Coastal Commission to leave an access area in the scenario that I gave. You're coming from a high point down a slope area. They might have been required to put in a walkway on their property to get down to the ocean.
Okay. Just out of curiosity, does that delineation between the private property that can't be accessed versus the wet sand that can, does that line move when as the tide moves?
It moves when the tide moves.
So it's not like a fixed amount, a fixed spot of this. The tide sometimes comes to this point, so therefore this is included. It's just wherever the wet sand is.
Right. So I have an association that has very expensive furniture that was on the dry sand. They also had some common area components that were part of that dry sand. And for a number of days in a row, the tide changed and touched the dry sand. And a homeowner came out one day and saw people who were not guests luxuriating on their beautiful furniture, recognizing that it was wet sand that day. Of course, there was an altercation. The police came, the Coastal Commission got involved ultimately, and the Coastal Commission, in order to avoid this again, came up with a set demarcation, sort of altering the high tide element, because this thing went south in a very quick way.
So there are people in the public who actually are aware of this regulation from the Coastal Commission and access the beach like that.
So aware of it. They used to call this the surfer's law. So they would know where they could go surfing and come back to the beach and have access to the public area.
Well, let's stay on the topic of where these conflicts can arise between HOAs and the public, but go back to the non-beach communities. If you have a gated community and there is a trail that goes through a gated community, is that viewed any differently than a non-gated community?
If there's no access point for the public and no easement was awarded in that property, no one is going to come through our gates and of an association to access into our trail. So there are times, as you were describing, where these trails are in the middle of properties, and that happens with our large communities. We envision them normally that they are on the exterior of the properties, so we don't have to worry about the people coming into the actual space, living space and recreational space other than the trails of an association.
And what other types of conflicts do we see between HOAs and the public on these access questions?
Normally where HOAs are contending that people, that either they don't have a recorded easement and they're willing to fight any allegations or contentions of a prescriptive easement, or frankly misuse of the property. And so signage is really important at the beginning and end of any trail. Large trails should have multiple signage. Look at various state laws on this as to what you can and cannot. Just like with pool disclosures, the font and size of the signage is also extremely important for enforcement.
I bet you're going to want HOAs to check with their attorney about how to get those signs right.
Absolutely something that is worth the money to get it right, because if you're fighting over it later, if you thought it was right and 5 years has gone by and all of a sudden there are prescriptive easements that you have no control over as opposed to a recorded easement, an association's moment in time, its life from that moment on, can change because their expectation that that was private has changed because they didn't get it right.
So if you have a community where there is some type of public access, and maybe there's not a formal easement, but the public has historically been accessing a trail, is there anything that an association can do if they say, hey, wait a minute, we want to close this off, this is our private property? Is the horse out of the barn on that, or can they address that in any way?
So the horse is partially out of the barn. Fortunately, part of it's still in the barn. And that is, again, a call to the association's attorney to discuss this. So somebody was saying it's 5 years, but we have 14 people that live there that say it is not 5 years. The most it could be is 3 years. And they're willing to provide declarations that every time they saw somebody using those trails, they said, hey, that's our association's private trails. Look at our signage. You don't belong here. That's fighting the open and notorious argument, which is a fundamental key point in being able to obtain a prescriptive easement.
And it seems that that can move into a very squishy area with respect to how a judge or just from a legal perspective, how that's going to be interpreted.
Very much so. But hearing what people say, for example, people who access the trails and say, hey, can I come in and use your trails? That's not an open and notorious use. They're basically letting you know that they believe it's your property and that they're asking for permission to be there.
I see. So is there any, you've mentioned, I think at least one, but is there any case law that is relevant and helpful in understanding this topic?
Well, the case concerning the billionaire and putting up the fence, keeping people out from his property, I think that's extremely relevant because that self-help didn't work. The Coastal Commission said you were obligated to come to us to get a permit. By that time, they're already mad. And so the chances of him getting the permit retroactively for that fence, that horse has definitely left the barn.
Yeah. Any other case law situations that should be considered?
There's a number of cases having to do with beaches and with trails. They're worth noting because if you are dealing with either, there's a lot of history at the appellate court level in a variety of states. And we want to make sure that, the call to the attorney happens beforehand, making sure we're protected as opposed to asking for permission later from a coastal commission is really the way we want to be. We want to go on the front end and try and make a deal for use that limits the association's liability and frankly, and with all due respect, limits the public from coming in to the extent that we have the authority to do so.
Sure. Is there a place for associations to have some type of a policy that they establish regarding public access if their community is one where there could be public access?
Absolutely. And it's an important policy because it doesn't necessarily mean the people who are coming in are going to abide by that policy. They have to abide by the posted signage for caring for our property, not leaving things behind like packing in, packing out, those kinds of rules that are universal in the Park Service. But it is an important policy for our homeowners and residents because they will be instructed in that policy how to assert that that is our property anytime they see somebody there that doesn't belong there. Information, town halls, communications, newsletters from the association to the homeowners explaining who can and can't have access is extremely important on this subject.
Yeah, that, you went right where I was going to go, and that is how do we communicate with the residents who are not on the board and maybe not really engaged on a first-hand basis. Because it would seem to me, and maybe you can tell me if I am misunderstanding, but if you have homeowners who don't understand the association's position on access to these trails or to a beach, and homeowners are communicating inaccurately to the public on a consistent basis, now that could lead to an opening where you could end up with an easement that you didn't intend.
Absolutely. Come on in. Sure, no problem. Come on in. Oh, I use it all the time. Well, you use it all the time because you're a homeowner. Yeah. Inviting somebody else in or giving authority that you don't have. So I think it's really important for the board to set the tone. We have these trails. We do have access rights because of whatever reason. Maybe there's an easement or we don't, and we don't want to provide it. And we're not obligated at law to provide it. Here's what you homeowners can do to help us make sure that on any of our watches, this doesn't happen.
Yeah, that's really helpful. Anything else on this topic that we have missed that might be important?
It is not that I don't appreciate that public has the access rights to beaches. I'm not a beach Scrooge, but I also know that associations located in beach communities paid dearly to get in. Both the developer in building in that area and the homeowners from buying in that area. To those areas that must be shared space under the Coastal Commission Act, we of course are always going to have our clients comply. But for those people who want to exceed the authority in the Coastal Commission, we're always going to have our clients fight back.
Yeah, oh, that's really helpful. Well, very interesting subject. Thank you, Sandra. Appreciate your insight as always, and I think people will benefit from this episode.
Thanks so much, Matthew. I appreciate being here.